Have you ever wondered why the first few lines of a contract seem more like a story than a legal agreement? The recitals section might look like fluff, but it can set the tone for everything that follows. Let's unpack why these early words matter more than you might think. I'm Mike, founder of Starlit Contracts. We're here to help you negotiate and use contracts with confidence, and today we're looking at recitals. Now let's get into it. Let's look at the recitals in summary now, and firstly, what is it? The recitals, also referred to as the whereas clause or background, provide the context for the deal. It generally describes what the parties did before entering into the contract and their intentions for the deal. So how does it work? Well, the recitals tend to be on the first page, or pages of a contract. The contract parties and the contract date are typically mentioned at the top of a contract and are followed by the recitals, which is sometimes known as the whereas clause or background. These recitals can range from 1 or 2 short paragraphs up to about 10 in complex deals. Recitals can be helpful by clarifying, with reference to pre-contract agreements or other facts, how to resolve an unclear right or obligation in the contract. Should you care? It really depends on the type of deal you're doing. If you're a supplier providing an off-the-shelf product, or the customer comes to your website, purchases something, and pays immediately without any relationship or negotiations, then recitals won't normally be so important. But if you've been negotiating with the other party for a while, maybe you entered into a non-disclosure agreement followed by a memorandum of understanding or some other document before you signed the contract, then adding the background to the deal in the recitals can be helpful. Okay, let's look at a practical example together. 2 companies disagree about how to interpret an important part of the scope of work. The right interpretation is not clear from the sale contract. Maybe the wording's ambiguous, or content is missing. The pre-contract memorandum of understanding and the minutes of meeting clearly show the intended scope at that point in time. So what can go right for the parties? Well, if the recitals identify those pre-contract agreements, it's more likely that if there's a disagreement and the parties need to go to court, the judge can look at those pre-contract agreements and decide how to interpret the sale contract based on what they see. Let's look at what could go wrong for the parties. If the contract has an entire agreement and non-reliance clause, you can see our separate video on that, then the parties are saying that the signed contract fully sets out the agreement, and that reference should not be made to their pre-contract communications. That leaves the parties with real uncertainty about how the scope of work should be defined, which will likely extend the time and cost needed to resolve a dispute. Let's look at a sample recitals, a sample whereas or background section, and some key considerations. First, here's the clause. Whereas the parties signed a non-disclosure agreement to discuss Party A's intention to build a factory and for Party B to perform civil works, and the parties signed a letter of intent dated 1st June 20th, whatever year it is, that specifies the main parts of Party B's scope of work. The parties enter into this contract to give effect to their agreement in the letter of intent. The last sentence is important because it shows that the intention of the parties was to enter into a contract to give effect to their letter of intent. So if there's a disagreement about the scope of work during performance of the contract, then the recitals prompt the parties to check the position that was set out in the letter of intent. The background for this example is set out in just 2 points. Ask yourself whether that is sufficient for your deal. In most cases, 5 or fewer recitals will be sufficient. Keep recitals short and to the point when possible. Also keep in mind that recitals shouldn't contain obligations. Obligations belong in the operative terms and conditions, in the body of the contract, or in the schedules. So here's what to remember. Recitals set the scene. They set out the background, not rights and obligations, and they can make it clearer how to interpret the contract when part of it is unclear. Keep recitals short and focused, usually just a few points, and use them to reference key pre-contract documents if you want that context considered later. If you have an entire agreement and non-reliance clause, be mindful that it can limit your ability to rely on pre-contract documents later. I hope you find this content helpful. If you're ready to speak with an expert or to hire a lawyer, then check out starlitcontracts.com, where we will help you to retain a lawyer or law firm to address your requirements. I look forward to seeing you there.